I have some questions on the adopted rules which become effective October 1. I know that in listening to you speak about it, we appear to be downplaying the actual impact of these rules, but a different reading might be that it totally upsets the established landscape in the state of New Jersey in terms of how we classify our workers. And what I'm speaking of specifically, Commissioner, are the 1.7 million independent contractors that call New Jersey home. Over the past 2 years, the Office of Legislative Services tells us that there have only been 7,000 reclassifications out of that 1.7 million. So my first question to you would involve some degree of speculation, but Commissioner, can we expect there to be more than 7,000 reclassifications under the adopted rules when they become effective?
Thank you for the question. I'm not sure where the 7,000 comes from, where that number comes from. What I can tell you is that last year our employer accounts conducted about 3,100 field audits, and in that they found over 14,400 workers who had been misclassified. That amounts to $1.3 billion in unreported wages and $32 million in unreported and uncollected contributions to the UI and DI fund. So I'm not sure what their number is, but I'm happy to look at it. But more importantly, to answer your question, I actually anticipate the number to go down because I believe that with clear guidance from the department as to what the factors to be considered are, those employers who are misclassifying their workers, not out of any malevolence or desire just to avoid taxes, but because they just don't know what the rules are, will be better equipped to follow the law and make sure that they're not doing that.
Thank you for that response, Commissioner, and I hope that you're correct. And when we're talking about the independent contractor in New Jersey, I think we're, by and large, talking about individuals that perform not just one job for one company, but perform a multitude of jobs, in many cases for a multitude of companies. That is what I believe gives rise to the term independent contractor throughout our history here of labor in the state. Am I wrong in looking at it that way?
I wouldn't say that you're wrong, but I would say that the problem goes beyond that. So for instance, right, we deal with misclassified workers in a number of contexts. In some contexts, it certainly is somebody who has, we keep hearing it referred to as a side gig or a side hustle. And I'll tell you, just having a second job or even a third job doesn't necessarily mean that the second or the third job is an independent contractor. Growing up as a kid, my dad had his main job, and then he had a second job at night and a job on the weekends. The difference was every one of those was considered employment, and those necessary contributions were taken out of his various paychecks. So having a side job is not in and of itself enough to say that that second job means you're an independent contractor. But in another context, I would also say we also see it's not even necessarily side jobs. In the wage and hour department, we see misclassification. A lot of times people who are paid cash wages and they're told, well, you're an independent contractor, so we're just going to pay you cash, and those things, we don't have to pay those contributions. And so those monies, again, don't get reported. I don't know that that's a second or a third job as opposed to their main job. So I certainly understand your question in that most of the contexts we see, I don't even know if I'd say most, in a lot of the contexts we see it, it's about a second or a third job, but that's certainly not the only time. It can be in other contexts as well.
I appreciate that. And in listening to you explain it, Commissioner, it would appear that from the perspective that you're giving us, that the new rules are on the side of the angels. We are now paying the fair share of what not only the employee needs to pay, but the employer is kicking in to the unemployment, to the disability fund, et cetera. But in actuality, I think the concern and the reason that literally 99% of the comments in response to the rule proposal were negative is because this threatens to drive business out of the state, and it threatens to shutter those businesses that rely upon independent contractors to serve the residents of New Jersey while providing income to individuals throughout the state. And so there's a different element or a different side to the story that I think we have to keep in mind when we're looking at the rule proposal. And I believe I heard you say, Commissioner, that the adoption of the new rules really doesn't change the law in this state. It's simply codified 90 years worth of Supreme Court and Appellate Division decisions. Is that correct?
That is correct.
However, the rules have been described as non-substantive, but in fact, they contain new standards by which not only businesses but employees need to observe moving forward. It literally does change the landscape. I understand your position that it affords clarity, but in affording that clarity, does it not impose new restrictions upon who can be classified as an independent contractor?
Respectfully, it does not. There are no new rules contained. There is literally just the adoption of the factors that the courts have looked to over the intervening 90 years. There are no new rules contained with this, so it doesn't change the test or the analysis of any of the prongs under the test.
But we're codifying the prongs, and we're talking about the 3 rules within the ABC test. Is that correct?
Not exactly. We're not codifying the test. The test was codified in law in 1936. What we're codifying is the case law interpreting each of the prongs of the test. So we're not the statute has been in existence for 90 years. That's not what we're codifying. We're codifying the case law, the common law, that fleshed out the factors to be considered for each of those prongs.
And I guess what is in part my confusion, Commissioner, there's been quite a bit of litigation, as you do suggest rightly, pertaining to the independent contractor test. In 2022, Uber paid, I believe, a record-setting fine of $100 million due to apparently its acknowledgement that there is a misclassification of its rideshare employees. However, today, are they not utilizing the same contextual description of who it is that drives around in a car and picks an individual up to take them from point A to point B? Are they not still all independent contractors?
So 2 parts to my response is, yes, they paid a $100 million settlement, and to be clear, that was on behalf of 297,000 New Jersey workers. That is a real impact to a great many people in the state. Whether or not they are still using the same business practices, I believe they are, but I disagree with calling them independent contractors. I know Uber continues to take the position that they're independent contractors. We obviously do not, which is why we brought the prior enforcement action to which you referred. We had similar enforcement actions against Lyft, which paid a settlement of over $19 million on behalf of another 100,000 workers. And so these are a lot of New Jerseyans who are being negatively impacted, and I think there's a recognition by those settlements that calling them independent contractors may not be supported by the law.
So in your view, they're employees?
Yes.
People driving around with the Uber signs on their vehicle are employees, but they're misstating the manner in which they operate.
Assuming all the facts are the same, all the facts are exactly the same as previously, that's correct.
So I envision that there will be another enforcement action pending in the near future against Uber, Lyft, or any other rideshare company that classifies its employees in such a manner, its independent contractors / employees in such a manner?
It's a distinct possibility. I can't talk about existing cases that the department is looking at or working on. We don't talk about these if we're in the middle of conducting audits, but it is certainly a possibility. If businesses are continuing to engage in the practice for which we already had an enforcement action, I think it's fair to state that we will continue to look at them to see whether or not the behavior and the acts that they're committing have come into compliance or not with the law.
I guess the concern that I would have, and many legislators I would assume would have, is that enforcement actions ultimately could result in driving companies out of the state of New Jersey. I understand liking to accentuate or brag, if you will, about collecting monetary fines against big business, but in actuality, isn't it the consumer, the passenger, that ultimately pays either through higher fares or the potential of not having Uber as a transportation option?
So I'll make a couple points in response to that. Whether or not the company chooses to pass on the amount of the unemployment insurance contributions and disability contributions to the end user is a decision for the company. At the end of the day, it's not the purview of the Department of Labor to make a determination whether or not this is going to cause the company to pass on those added costs to the driver. It's our job to enforce the law and protect the workers. To the first part of your question with respect to the premise that it would somehow drive employers out, I would submit to you that over the course of the last 8 years, a number of worker protection laws were enacted, passed by this legislature and enacted by the prior administration. As we sit here today, we have more employers in New Jersey than in its history. We have 297,000 registered employers today. Last year, we had 290,000, and 5 years ago, we had 250,000. So the number of employers has actually increased in the last 5 years by 47,000. Similarly, we have more workers, more New Jerseyans working today than at any time in our history. 4.66 million New Jerseyans are currently employed. That's more than at any time in our history. So I would suggest that some of the data, if we look at it, actually suggests the opposite, that these worker protection laws that we put into place, that you, the legislature, enact and that we enforce, is not driving businesses away.
Well, respectfully, Commissioner, we're also the state with the 6th highest unemployment rate in the nation. I think everyone will acknowledge to a degree we're in competition with our immediate neighbors. By enacting certain protections, I believe we're doing a service to the people that are employed here in the state. But if we begin misclassifying individuals who enjoy their independent contractor status, are we not then acting absolutely to the contrary of the affordability economy that you had acknowledged in your opening remarks that Governor Sherrill promotes? You know, I don't know that we can have it both ways, Commissioner. And it would appear that we are waiting for the adoption of these rules before taking additional enforcement action. And that's a little bit concerning as well. Any response to that?
Yeah, so I would say this. The unemployment rates that you referenced about New Jersey, our rate is lower than one of our neighbors, Delaware. It's slightly higher than it is in PA or New York. If the premise is that lower cost is going to drive all the businesses out of New Jersey and into other states, one would expect to see Pennsylvania to have near full employment. Its minimum wage is still $7.25 an hour, but that's not what we're seeing. In fact, last year, New Jersey created more jobs than Pennsylvania did, despite its lower unemployment rate. And so I think it's dangerous to look at one single factor. I would also take issue respectfully with the suggestion that the department has held off on subsequent enforcement action until the promulgation of the rules. I haven't said that. I'm not sure what gives that, but it's not what we've done. because quite frankly, at the end of the day, the rules are codifying the existing laws. The actions, the enforcement actions that you and I have spoken about, like with respect to Uber and Lyft, you'll recall, those enforcement actions took place successfully, I might add, prior to the adoption of these regulations. So from that point of view, I would suggest to you that the regulations are, as I've stated, merely a codification of the case law for the benefit of the business community so that they have an easy place to go and look, as opposed to some sort of added tool the department is taking upon itself to enforce.
I think respectfully, and I'm almost finished here, is the fact that we are now removing certain defenses that employers previously would have been able to use in response to a complaint by the Department of Labor that we were in fact misclassifying employees. We are now codifying an ABC test to which perhaps there is more clarity, but on the other hand, to which there are fewer defenses to permit the retention of the independent contractor here in the state of New Jersey. And ultimately, it comes down to how do we best serve the residents of the state, keeping them safe, but also permitting a free market that is going to be affordable. And I think that in the context that we're dealing with here is really the key word. That affordability economy that you reference, I don't believe is well served by what is proposed. Food for thought, Commissioner. Thank you, Madam Chair.